My lord. My lord, under the compelling circumstances, though I know my lord doesn't give the.
So why do you want to mention matters today? Because I'll not be there from Monday.
I know, my lord, the urgency is that, my lord, on 31st 3 p.m. there will be a demolition under section 10.1. Whereas 10.2, 10.3, 10.4 has not been followed. Now, my lord, I would have filed in the department. Thereafter, I would have mentioned. But I cannot serve the other side unless and until, my lord, 48 hours will be there. For such reason, leave may be granted. I can
be
and I will.
Demolition under 10.1. So please show me the notice where they say they'll come and demolish. They've asked you to remove.
No, my lord.
Please show me the notice.
Yes, my lord. This is the unfortunate thing.
How can there be demolition under 10.1?
10.1, not 10.1, my lord, final demolition. Final
You
demolition.
said 10.1 just now.
10.1, they have invoked pursuant to your lordship's direction. Now, my lord, complete. On 31st, if your lordship kindly sees once. I know my lord will not be there. My lord, leave is required. First, my lord, we are to be informed that you are to remove. That is not there. Thereafter, 10.4 is there. Appeal.
Yes.
We have filed it. That we have taken the specific plea that we have not been served any notice.
And this is government land, maybe under the 62 Act.
No, my lord, it's 64.
64.
1964.
Where leave is granted.
My lord, I am great.
Item 46 of today's list, my lord, Mr. Sengupta is appearing for the state.
সোমবার মঙ্গলবার কোন একটা ডেট দিয়ে দিন
My lord, item 46, my lord, Mr. Sengupta is appearing on behalf of the state. My lord, he has some personal
It will
difficulty.
be
my lord.
called, sir. Please do not mention today's matters.
My lord, my lord,
But I'm seeking not today for that, my lord, only that.
my lord,
Mention, tell me when it is called.
may I be
No.
permitted to disturb your lordship once again, my lord? My lord, item number 63 of today's list. My lord, by specific direction of this honorable court, the my lord, District Magistrate Bibhum forwarded the proposal for extension of sand quarry permit and refund of money. My lord, is pending since my lord, July 2022, and thereafter the matter your lordship directed to file report. Thereafter matter there.
It's pending in the supplementary list, so please wait for your turn.
Kindly fix any date so that the report can.
It is fixed today itself. So come back. Let me see if I can reach. Yes, days list.
Days list must have, my lord, any specific date so that I can serve
Cannot
notice.
be. Let me call the days list.
Item one.
I mentioned one extension in order. It will expire
Not
on
possible
31st.
because mention on Monday.
My
Whoever,
lord,
whichever
that
date is
order will
there.
expire on 31st July, my lord. That matter is
I
running in,
cannot take up the file
my
today.
lord, it is running in lordship list for hearing, my lord. Group one matter. That matter is running in lordship.
Should have been mentioned yesterday, sir, in that case.
I don't know.
So please come back on Monday. I will not allow any mentioning.
Then-
Yes, call the days list.
Item one.
It appears that the writ petition has been disposed of by an order passed on November 2, 2017. Paragraph in view of the same. The order dated January 13, 2023 is set aside. Urgent certified person. Arrangement dismissed.
Item two.
Item 2, I appear for the petition, my lord. This is for extension of interim order. The interim order is expiring on 31st of July. The lordship was-
Notice.
My learned friend is appearing. No? হ্যাঁ স্যার আপনার নাম আছে আগে
Mr. Dey is appearing in one of the matters.
Yes. But
Mr. Sengupta in the other matter.
I do not know whether he's still there or not because there's a change of lot as I find.
It's a hearing matter.
Yes,
Affidavits are exchanged.
Lordship.
Let there be a date for hearing, let it be extended for some time. And the matter is ready for hearing. Paragraph, let the matter appear under the heading hearing
সুশোভনদা যেটাতে ছিল
on 4th September.
as your lordship pleases.
Paragraph, the interim order granted earlier is extended till 30th September or under further orders, comma, whichever is earlier.
Agreed.
4th and 30th.
Agreed.
Group one.
সুশোভনদা যেটাতে নেই সেটাতে আপনি করে দেবেন আপনি হয়ে যাবেন ও তো প্যানেলে নেই
Item 4,
সবাই জানে। আরে ঠিক আছে 4-5
State matter, item number 4.
extension.
No, not extension, my lord. It's a come under the wrong,
Recorded as extension.
wrong noting. If your lordship kindly turn to your lordship's order dated 9th of February 2023.
Slip it. It is for extension of interim order. That's the slip, mentioning slip says so. কোথায় extension দেখালেন আপনি?
This is the extension. Now, this is the order of 9th February 2023.
Yes.
Till date, they have not taken any steps.
Who is appearing for 7 and 8?
Lord, I am appearing. Lord, my learned friend is saying that I have not taken any steps. Possibly, my lord, he was not properly instructed, my lord.
No, possibly my learned friend is not aware about that.
But what happened, I
9/20.
am telling you, Lord.
No, my lord, division bench, they were supposed
But
to
I'm-
file a review application before the division bench. That has not been done.
Lord, what has happened, I am telling. When the matter was taken before the single judge,
Again,
my advocate on record by mistake submitted a report,
this-
which is not his report of the district magistrate.
Now
the
this
same
No, Lord,
thing is-
I'm coming, I'm telling. Now, my lord, thereafter, my advocate filed an explanation before your lordship that what happened. This explanation was filed on 31st of January 2023
this court.
before this court.
Immediate-
No, I'm telling. Then they came to me that this happened. Then I said, why you are not complying with the order of the division bench? Then I advised him, if please comply the order of the division bench. Then this is complied. Though belated, that is complied. The copy was served to them.
What he is saying, my lord, I could not follow what he is saying. I have been served with a compliance report of your lordship, and considering this, your lordship passed his order on 9th of February 2023.
Yes, 9th
And
of February.
division bench, they have to comply the order of the division bench, meaning thereby whatever has been filed before the justice passed.
Yes, copy
Yes,
of the report.
where is that report?
We said that
In the court.
দিন তো ওটা দিদি। What is this that you are submitting?
the report which I have my learned advocate filed before the court, that report that I have served with them.
This is not the
Division
report of
bench-
yours.
No, this is not my report.
Oh.
This is not my report.
But it was recorded that 7 and 8 filed a separate report.
Were you directed to file this report by the division bench?
Yes.
Not specific. Division bench directed to submit the report, report which I filed in the trial court.
Yes.
This
So the-
report I filed in the trial court. By mistake,
So
that I have
so
said
that
in
is
my
the reason, my lord,
explanation.
your lordship directed them to take steps to correct that order.
The report which I have filed in the trial court, division bench asked us
The
to,
order of the trial court.
Yes. The order of the trial court is lordship, my lord, that is
The order of the trial court dated 5th March 2021. Where is
yes.
the order?
The 25th, April, Lordship,
March
এটা একটু
2021.
Josephকে দিন না।
It's not annexed to the writ petition?
My lord?
Not annexed?
No, 5th March order is after moving the writ petition. I moved this Justice Basu. And my lord, on 5th of March, considering my writ petition, now 2 reports were filed. One by state. I allege this that without acquiring my land, you are going to construct the land. On the basis of that, state file and report. 7 and 8 also file and report. So I said, the let a copy be handed over to me. Then I preferred an appeal against this order. In the division bench also, I pointed out that that copy has not been served upon me. The division bench directed them to hand over the copy.
Please show me
So-
the 5th March order. What reports were
Yes.
submitted to the single bench?
Third,
This report was filed on 5th March 2021.
yes,
before the
yes,
court.
yes.
So
yes,
you are
yes.
annexing the same report?
Yes. And my lord, if
At
you
page-
lordshiply take my explanation for once,
Where
then the
is your
matter will be clear. What mistake I have done in the trial court.
so you must clarify that.
That I have
You must know,
clarified.
you have to
No,
take steps.
I
because
have
the division
clarified
bench-
that.
You have division, in the division
But
bench also
that
you
I
have to
have-
go to the court.
Lord, that I have clarified. That what mistake I have done.
So you say that these reports are not connected to the writ petition?
No,
You
connected,
filed them inadvertently.
Lord, what I have said, Lord, your lordship take my this explanation that I have filed this before your lordship, it is the paragraph 4.
It is here before me. Paragraph 4.
4. Explanation is paragraph 4. The fact remains here. I feel lordship got it.
Paragraph 4 of the report that you're giving today.
Explanation filed by your affidavit by my client on 31st of January 2023.
But in my copy, I do not find any paragraph 4.
No, not today's report, the earlier explanation here.
No, my lord, this is the explanation which was served upon me on 2nd of March 2023.
No, seta na.
The next copy I have not been served.
10th
No, I'm
November-
telling my
10th November 2022.
no, this is affirmed on 31st of January 2023. 31st January 2023. Have you lordship got it?
10th November, no.
30, Lord, your lordship, I'll take my copy for once.
Give me a minute. It should be on record. Give me a minute.
That should be on record. There are many.
But a copy may be served upon me.
I have-
so that I can-
এটা তো দেওয়া হয়নি এটা তো দিয়েছে এই কপি
কোথায় আমার কাছে নেই কোনো কপি? What is he saying?
মানে ওটা তো ওই রিপোর্টটা এই যে দরখাস্তটা ফাইল করুন এক্সপ্লেনেশন এটা ওদের দেওয়া হয়নি
Served with any copy.
Let me find out if it is there on record at all.
I have every doubt that has been filed even.
হ্যাঁ কোর্টের অর্ডারই রয়েছে রে বাবা
Explanation
this is
matching
all
the
the-
affidavit, 31st January, yes.
Now, this paragraph 4 you'll also kindly see that explanation that will make it
Oh,
clear.
the copy is also on record.
Yes, copy is on.
But I have not been served with any
This is the
copy.
copy. Didi? Copy আর original দুটোই ফাইলে আছে। কপিটা দিয়ে দেবেন মিস্টার পানকে দিয়ে দিন।
Paragraph 4, Lord, what mistake I have done, that I have explained in paragraph 4. That mistake my learned advocate has done in the trial court.
This explanation has to be dealt with by the honorable division bench.
Yes.
Because it's the direction of the division bench, I cannot lay
But
my hands
what-
on this.
but-
order.
Yeah, and on the basis of direction, that I have served him the copy. That is the other bunch I have given to you.
But, I don't know what
Second
he
March.
is submitting. My lord, this is
The
the
report
report.
which I have filed in the trial court,
Kindly see.
that I have given to him.
No.
2nd March.
Problem is this, my lord,
Tell you,
while
Lordship, I
disposing
see.
of the appeal,
appeal
Division bench,
disposed of,
division bench directed them to serve me a copy. So you have to take steps before the division bench.
You have submitted.
Now,
a
why
copy
is
of the
avoiding that?
DA, which is of the district magistrate, not
That-
of 7 and 8.
that this report was paragraph 4 I have stated, that report I mistakenly filed in the trial court.
So this has to be explained before the.
Trial
division
court,
bench.
because that is report, in the trial court I filed this report.
Before the division bench, not before.
Division
I
bench
have
only said,
Comply with the
may,
order. of the
may,
division
may
bench.
clarify yours.
Yes.
Division bench only said the report which you have filed in the trial court,
Hmm.
please supply a copy to him. This is the order of the division bench.
Division bench says two separate reports were filed, one by.
Yes, two paper reports.
One by the state and one by 7 and 8.
Yes, correct.
7 and 8 also has to be filed.
Yes, this report, paragraph 4, I have said what I have filed in, what report I have filed in the trial court. That in paragraph 4 I have explained. By mistakenly, I have filed this report before the trial court.
Mr. Pan, will you go through the reports and come back?
Yes. Let me go through the.
This is my
And
mistake I have done.
moreover, my lord, kindly record that today I have been served. See the conduct. Even then, this has not been served upon me for the last 7 months.
Lord, on 2nd March, Lord, I have handed over.
The copy was in the record. It was
No.
not handed over to the, to
Oh,
learned counsel.
This
The earlier copy
explanation.
was- Explanation also.
No, that.
Report submitted on behalf of the, on behalf of the 7th and 8th respondents is taken on record. Paragraph, copy of the said report as well as copy of the explanation submitted on 31st January 2023 are made over to learned counsel for the petitioner in court this day. Paragraph. Let the matter, you can take this back. I think this is in the file.
Well.
It's a fair deal, Mr. File. Let the matter appear under the same, under the heading, it's a motion,
Motion.
under the heading group 1 motion on 29th August.
Lord, the report which I have sub to them, Lord, may I get back the copy, the endorsement?
I have given the copy to
No, that, not that.
Mr. Pan.
Another bunch, Lord, which I have handed over to the to showing that I have served the report to him on
That is
2nd
a
of March.
Submitting in court, how can you get it back? I have taken it on record.
That report.
Yes. Next,
4 and 5 are the same.
yes.
Item 6,
29th August.
I appear for the KMD.
I am appearing for the petitioners and this matter has come up at our instance for extension of interim order. Lordship was pleased to take up this matter yesterday when some submissions were made by my learned senior friend regarding the bank guarantee, which has been
Yes.
renewed, and I would just want you to have a look at this copy. It has been renewed till 12th of October 2023. And there has never been any default on our part in renewing the bank guarantee. My humble prayer is to extend the interim order because it is expiring on 31st of July 2023.
After renewal, it would be submitted to the KMC.
It is
They should.
submitted to the
They have not submitted to the KMC, my lord. They have written only letter. Nothing.
Yesterday,
And,
yesterday it
yesterday
was
also.
submitted on behalf of the petitioner that they are not obliged to renew even.
No, Your Lordship.
That-
I'll.
That was-
that count.
Your Lordship,
Hasty
the sub-
submission made.
Now, the submission the submission made by Mr. Bag, who was appearing for the petitioners, was not that we were not obliged to renew the bank guarantee. Probably he meant to say that they were not obliged to give the copy of the bank guarantee to the KMD. I humbly apologize for that.
Not
That was
KMD
not-
to KMC,
that-
because
that
it was
That was never the intent, Your Lordship.
earlier on the same cause of action, one writ petition was filed.
Now, if the intention
There-
differs from the submission, it becomes difficult.
This is the order I have brought. In the earlier writ petition, what order was passed. On that basis, my lord was pleased to.
Come back. It's a hearing matter?
Hearing
Yes,
matter.
Your Lordship.
Affidavits are exchanged?
Ready matter, ready matter.
Cannot
Your Lordship was also pleased to hear it partly. Mr. Shakrinath Mukherjee, he was making submissions.
Right,
on one
right. I can
occasion.
recall. I have taken notes also.
Yes, yes, Your Lordship.
Uh,
If you challenge, then
heard learned
we have to
counsels for
accept
the parties. Learned counsel for the petitioners produces documents to show that the bank guarantee has been renewed. Paragraph, let the matter appear under the heading hearing.
Well, madam, let them submit that bank guarantee with us.
They
Otherwise,
have submitted.
let them submit.
They have not submitted, they have only renewed.
Your Lordship. what was
You are
said?
saying renewed.
6th September.
6th September.
Paragraph, the interim order granted earlier is extended till 30th September or until further orders, comma, whichever is valid.
And my opposition may be kept on.
Affidavit in opposition. Hearing has
Maybe,
started.
it was not filed on the earlier occasion.
Affidavit in opposition submitted on
Yes.
behalf of the
Hey,
behalf
আমার
of
একটা
KMC. KMC is taken on record.
KMC for-
Masul.
Great.
And madam, you, when the bank guarantee will be, they will submit it, madam, within 2-3 days, madam, they let them.
This
By
is
31st.
submitted before the KMC.
My instructions it was submitted
Please
with the
find
KMC, not the KMDA.
No,
That
no,
is
no,
my. that is
KMDA,
my-
KMDA,
you
they
are
have
not,
not submitted.
you are not to submit before us.
I am submitted with the KMDA. Let them submit with the KMC.
Is it submitted? The KMC
Lord, kindly give me a
accepted
moment,
it.
Lord.
Your Lordship, we'll,
I have extended the order.
My lord.
It's till 30th September here.
Very
date is
deeply
not
obliged.
fixed, but please ensure submission of bank guarantee before the KMC.
Lord, we will inquire it from our client, but my lord, subject to correction, my lord, submission of a bank guarantee is between the bank and my lord, the entity who is applying for the bank guarantee. If they want my lord to know whether the bank guarantee is extended, because the rule is that unless and until it is extended, my lord, if it is extended with the bank, we have fulfilled our obligation. If they want to know, they should write to the bank. It is not our, my lord, obligation under the law to intimate it to the KMC or the KMDA.
No, this is perhaps he is not correct.
Subject to correction. They
Earlier
can show that
occasion,
law is different, my lord.
what-
The last I checked, this was the law.
what give rise to this application, writ petition? Because KMC was attempted to invoke the bank guarantee. Challenging that action, the writ petition was moved. So bank guarantee has
Sir,
to
let
be
us-
furnished
Let
to
me
the KMC.
allow me to put to
ensuring
rest this
that.
entire dispute. We will intimate them.
Why don't you come back on the next? Yes, yes.
We'll intimate
That,
them.
For the
We'll
time
do
being,
that.
come back for the-
Intimation
We'll do that, my lord.
will not do. KMC must have that
We'll-
document.
With the document, definitely with the document. Definitely with the document. A copy of the document.
Intimation cannot be a verbal intimation.
Yeah, we'll definitely do that. Lord, if your lordship is only pleased to fix up any particular time, my lord.
Time is not possible. I'll fix up a date.
6th September, I'm instructed, my lord, your lordship has been pleased. If my lord, any particular time,
Not possible if this court is still. Come back, let us see.
we'll do that. Lord. We'll do that.
Because that has to be done in the meantime. Otherwise,
We'll do that in the
the
meantime,
interim order
definitely.
would have no,
From the bar.
yes.
We'll definitely do that.
Next matter.
I'm deeply obliged, my lord, deeply obliged.
Now he's,
Item 7.
they are changing their stand. That is why.
Change ko children.
Masul.
Even I'm for the petition also.
Yes.
Is my instructions.
You don't want to proceed?
No.
Learned counsel for the petitioner submits that he has instructions not to proceed with the matter any further. Paragraph, written instructions submitted on behalf of the petitioner is taken on record. Paragraph, in view of the above, the writ petition being WPS such and such is dismissed for non-prosecution. Paragraph, there shall however be no orders to costs. Paragraph, urgent certified website.
Instructions may be kept with them.
It's taken.
Item 8.
So I believe the matter has already been disposed of and there is a subsequent writ petition. There was an order passed pursuant to the order passed by this honorable court. There was a adjudication by the ADM and thereafter that order has been challenged in a separate writ petition.
There's a printing mistake. That's why it has come up. Now, Rajiv, your order. Inadvertent error has crept into the order passed on 27th March 2023. In the third paragraph of the order, CAN 15 of 2023 be read as CPAN 15 of 2023. Paragraph, the department is directed to make this necessary correction accordingly. This order be treated as part of our urgent certified website copy. Item 9.
My objection also. I have informed the GP office and this is the letter for the non-prosecution. Proceed kindly liberty to file a FCS. There is some mistake in the.
Liberty. Who is appearing for the respondents?
I have.
If you seek liberty, it has to be served. Dekhi.
No order has been passed. Proceed. No order has been passed.
Mr. Roy was appearing for the state. Mr. Partha Pratim Roy, Mr.
Proceed,
Pichai.
I have given the letter, Lordship, and GP officer received it. And some good side also there.
You have stated for non-prosecution, you are asking for withdrawal with liberty. It's a wrong notice that you have served. You have to serve afresh.
And
And
non-prosecution. Lordship.
yes, non-prosecution. The notice is for non-prosecution.
This is the Lordship, their client. We are getting law.
The notice is not by the client, it's by learned counsel.
No. Oh, this notice. Oh, no.
Yes. So you're asking for non-prosecution or withdrawal? Non-prosecution. It is submitted, learned counsel for the petitioner submits that the petitioner does not intend to proceed with the matter any further. Paragraph in view of the above, the writ petition being WPS such and such is dismissed for non-prosecution. Paragraph, there shall however be no order as to costs, urgent certified website copy. You can take back this instruction. It's a
Yes.
different instruction altogether.
Yes.
Item 10.
My lord, in this matter,
I have
my
got
lord, in another matter, I have raised this issue, my lord.
Hmm.
My lord, this is also group 5 matter, my lord.
Group 5.
Group 5 matter.
This is the land matter actually.
Group 5 will release for it. It's a group 5 matter, sir. I have to release it.
But this is for extension
Cantonment.
of interim order till 31st.
Group 5 matter, I have to release it.
No,
Question of
it is not a group 5.
My
It is
lord,
a land matter, group 1. I have.
অন্য ম্যাটারে ম্যাডাম করেছেন ক্যান্টনমেন্টের ম্যাটার এর আগে দেবাংশু বসাকের আছে
Madam, we have challenged the notification of the
Cantonment board.
cantonment.
Cantonment board.
Cantonment
Cantonment-
municipal. This come under the municipal.
No, municipal can, at a land matter.
Ah,
It is
this
the
is-
land.
It is not land matter. Please see the statute, sir. Please see.
Earlier also your lordship was pleased to
I
direct.
have released the other matters earlier. This, after this was
সেকশন 10
pointed out to
সেকশন
me.
10
But I shall see it. Madam, in the meantime, you are
I cannot.
extend the interim
I
order.
cannot because it's, I do not have determination.
But
Once it is pointed out to me, I cannot.
but this is the land matter, Milord. We have challenged
Land
the
matter, I'm
notification.
Well,
It is
they can
for-
bring-
Kindly see the Milord, kindly see the
Subject to
file,
the
Milord.
of the
My file,
respondents
kindly
For
see.
some
that the
disconnection.
matter pertains to group
Otherwise-
5 of the classification list. In view of the.
এটা তো আগে বলা উচিত ছিল এখন বলছি।
In view of section 10 within bracket 2 of the Cantonments Act, 2006. Yes.
Madam, let me see. I have to check the Milord then, Milord.
আরে
No,
sir,
further, I cannot
again.
extend your orders. Please, it's better if you.
Let it taken up 2 PM, Milord. I have to,
No, I can't.
I have to check the Milord.
In view
it
of the same comma, the matter is released from the matter is released due to, in view of lack of, due to lack
আপনাকে
of.
অর্ডারটা যখন দিচ্ছি তখন দেখছি
ওই সুবিধাকে পেলাম না।
আগে বলে
আমি নিচ্ছি না order।
আমি কি
Next,
Earlier
item 11,
earlier occasion they did not raise it.
না, ঠিক আছে।
item 11. Correction আছে করে মনে করবেন। Oh, section 10 of the National Highways, right? Inadvertent error has crept into the order passed on 12th July 2023. Paragraph in the third paragraph of the second page of the order, comma. Section 10 National Highways Act 1964 be read as Section 10 of the West Bengal Highways Act 1964. Necessary correction, Ajit?
Item 12,
Lordship, I am for the petitioner. Lordship, interim order is expired.
Item number 15, I am for the petition.
item 12,
12, I am for the
But
petitioner.
12,
Lordship.
13, 14, 15, 16,
Yes.
all of the same cause of action. Only one of the defense of the petitioner is that they are not being heard. The order was passed under section 3 of the Unauthorized Occupancy Act 1962.
Yes.
You lordship may dispose of this matter by directing the collector to hear fresh and pass a fresh order.
Lordship, that is not, I don't know in which matter my learned fin is appearing, probably not in my matter. My matter.
No, item, I in item 16.
Because in his application, I was not allowed to make submission. Yes, item number 12, I am for the petitioner. He is not in the item number 12.
No, item 16, I am
Yes, yes.
appearing.
Item number 12, who is
Yes.
appearing?
All are same cause of action.
Maybe, who is appearing in 12?
I'm Lordship, yes.
I am appearing for.
I
the
mean,
state
12 led by
respondent,
Mr.
but the last time it was told. that I am-
item 12
Item 12 too. I am appearing for the 12 for state respondent.
After the petitioner in item number 14.
সত্যরঞ্জন বারিক তো তোমার
আমি সত্যরঞ্জন বাড়ি।
তুমি কততে আছো?
14, 14.
Eight.
14 Sorry, then I'm sorry.
All the matters are being taken up together?
Yes.
Yes.
You lordship may dispose
There
of.
is an appeal pending.
Yes.
Lordship, appeal before the starting in one of the petition, Lordship, not the entire lot.
They're all similar matters.
They will never appear in that matter. They will never withdraw this appeal.
I mean, I even don't know who is, whom my learned fin is representing, so I am not able to respond to him, Lordship. I don't know who is the party.
Admittedly, an appeal is pending that has been recorded in the earlier order.
Yes, in one of the petition.
Till the appeal is disposed of, I cannot proceed with these matters.
Yes, kindly accept the interim order. Yes, yes.
One of the petitioner prepared an appeal against the order of the fellow SDO. But this appeal, the petitioner didn't appear before the lordship. On the earlier two occasions, they didn't appear. Now, only.
Yes, since I've put the matter out of place, that's why there's no.
That's why you
No,
lost.
why?
That's why.
My
But
opinion
since
is
again, the matter was mentioned, just say you lordship dispose of this matter by directing the.
No,
Then the
no,
appeal
no.
is pending, I'll dispose of
An
this.
appeal
No,
will
no,
be,
no, lordship.
appeal, I tell lordship.
Yes.
Appeal has been favored because they are the same cause of action that they are not having been heard. Same issue.
So can a single bench dispose of matter? What are you?
If they do not withdraw this appeal, I told us, if they do not withdraw this
Single
appeal,
bench
if
cannot
they
be
did not
extended.
appear before lordship, then you lordship dismiss this matter.
It's out of place, it's only for extension of the. interim
Yes,
order.
your Lordship.
Then it should be extended for a limited period. of
No,
time.
only one thing, again, they will
And-
mention for extension of interim order. How long the interim order will be extended?
Date for hearing, file.
Yes,
Kindly fix one date.
before
After
the appeal
extension.
is disposed of,
Let the appeal disposal.
cannot be.
But they will not withdraw this appeal, they will never appear. They let that matter be dismissed for the board, because they will never appear.
The matter is out of list.
Again, is out of list.
The matter is out of list in view of the order passed on June 19, 2023. Paragraph, since the interim order expires on 31st July 2023, comma, the said order is extended till 31st August 2023 or until further orders.
And only one thing I will make a submission. Well, they will not, they will never appear to Lord.
The matter
And if
is-
that be so, let that matter be dismissed for the board.
It's out of list already.
Again, after again, this matter will be mentioned for extension of interim order. Well, this should be going on. I am putting
Can't help,
question.
appear before the appellate court and make your submission. Next matter. I will not touch the matter till the appeal is not disposed of.
But then this matter will be dismissed for the board. They will never appear before lordship.
Next matter.
Item 17.
এই 14টা নেবেন এটা।
On 26th of June, Lordship was pleased to pass an interim order protecting my interest till 31st of July. I put my learned friend on notice, my lord, he's appearing. And Lordship further directed them.
Yes, my lord, I am appearing on behalf of Union of India.
Yes.
Lordship directed them to use an affidavit within 2 weeks. That time has
No, your
lapsed, my
lordship
lord.
kindly extend the interim order for a limited period. Within this period, we will exchange the affidavits. It is ready. Today it will be affirmed. On Monday, I will serve.
Learned counsel for the respondents seeks extension of time to use the affidavit in opposition as called for. Paragraph. Since the interim order expires on 31st July 2023, comma, the said order be extended till 31st August 2023 or until further orders, comma, whichever is earlier.
Matter to be listed on this.
It is out of list already. You have to mention upon completion of affidavits.
Lordship.
That has been recorded on the earlier date.
If your lordship kindly fix the matter after.
Because at present there is no affidavit, my lord. Let the affidavit serve.
Monday I will
I will
serve.
use my reply.
On Monday, I will serve.
And
it.
after,
The affidavits, he has to give a reply.
I
to
will
it.
mention for a fixation, my lord.
Absolutely.
Lordship.
Next.
Lordship, I have appeared.
On behalf of the petitioner, the matter was disposed of on 19th July.
What's the correction necessary?
Mentioned, yes, my junior friend has not, name has not been recorded. Mr. Debrai name
Name
has
has not been
but
recorded.
his junior has not, name has not been recorded. After Mr. Debrai, my junior friend name should be.
No, for the state,
My lord,
inadvertent error has crept into the order passed on 19th July 2023 in the cause title of the order. The name of Mr. So-and-so, owner number be recorded as learned counsel for the state in addition to Mr. Kantu Devra. Necessary correction, department to sort which we did as part of for as certified website. Next.
19.
19, my lord, I am for the petition. Application for.
Restoration.
Yes, my lord.
Served,
No, my lord.
put the other side of notice.
Sorry, my lord, sorry. My lord, application filed within time, but not. served.
Maybe, but you have to put the other side of notice.
Yes, my lord.
Then was anyone appearing in the petition?
Order is there.
State
No.
did not appear.
No order.
Let it be restored, serve notice after that.
My lord.
Restoration. Restoration. Can disposed of paragraph WP heading bin, let the matter appear under the heading group 1 motion on 4th September.
My lord. Is it?
Service affidavit of service is not there on record. Paragraph affidavit of service be
I shall
submitted on
serve
the
the
date.
copy of the writ petition.
20.
4th September, my lord. Great.
20.
My lord, item number 20. In this matter, my lord, I have been appointed by learned LR to continue with this matter. Previously, I was appearing in this matter as on behalf of the state. My lord, your lordship has the direction for filing an affidavit in opposition. My lord, affidavit in opposition I have made ready.
It's appearing for the petitioner. Anyone for the petitioner?
Petitioner is not there, my lord. This is long pending matter, my lord. However, my lord, let me, my lord, permit to, my lord, file the affidavit in opposition today. Opposition দিয়ে দিচ্ছি, কপি আমি সার্ভ করে দেব।
None appears for the petitioner. Stop, no accommodation is sought. Affidavit, none appears for the petitioner. Stop, no accommodation is sought. Paragraph affidavit in oppositions in connection with the amendment application being Can 2 of 2023 filed on behalf of the state respondents is taken on record. Paragraph, let the matter appear under the same heading in the monthly list of August.
Great.
Fifty-one.
My lord, I appear on behalf of the petitioner. My lord, the writ petition was filed for implementation of a particular order, my lord, of an authority. That order was under challenge at the instance of the private respondent, my lord, in another writ petition which was pending before Justice Moushumi Bhattacharya. Therefore, my lord, instruction given to the learned advocate was that until that petition is disposed of, this one can't continue because this one is for implementation of the order which is being challenged in that petition. My lord, the learned advocate on record withdrew the writ petition.
Yes.
Now, my lord, this withdrawal therefore means that I have abandoned my challenge, abandoned my right to implement it forever.
That without liberty, I'm sorry, nothing can be done.
Lord, only one prayer.
Liberty was also sought. Have you served the other side?
I've served the other side. I have also, yes. Lord, if I may be given liberty, my lord, to reapply in the event they lose there. Otherwise, my lord, by order 23 rule 1, there's an abandonment of my right forever. Even if they lose there, I won't be able to enforce the order. My lord,
Conscious abandonment, what can the court
it was
do
not
now?
conscious, my lord. I'll tell you, lordship, why. The petitioner had told the
It's also not conscious?
learned counsel was no, my lord. Learned counsel is my agent, my lord. I'll be very frank to you, lordship, my lord. He is my agent. My lord had said that if you want to take steps in another forum, you take it, you withdraw this, my lord. That was his prayer. The actual thing is, what he ought to have prayed is what your lordship has done just 2 or 3 matters ago. Delistment of this writ petition until that writ petition is heard out.
But that was not the prayer at all.
That was not the prayer. This is not a conscious abandonment, my lord, of the petitioner. Petitioner's right will be finished, my lord. Even if he succeeds there and the authorities don't take any further steps, he won't be able to enforce that, my lord, by filing a fresh writ petition. This will act as an abandonment, my lord. Only clarify that part. I've served everyone, my lord. In the event, subject to the result of that, I can file a writ petition on the same cause of action for implementation of the memo. If your lordship has a copy of the writ, my lord, the written copy.
I have my doubts as to whether this can be done. I would like to see provisions or authorities on this. Once you withdraw a petition consciously without seeking liberty, how can you?
I'm only seeking, Lord.
You're asking for restoration of the writ petition.
After
Withdrawing it on your own, how can you do that?
Restoration or clarification of your lordship's order. Clarification of your lordship's order, it would not stand in the way.
No question. There was no prayer at all.
At that point of time, there was no prayer. Lord, kindly understands, Lord, what injustice has been done to the petitioner by someone, my lord, who's wearing robes and representing him, by what he has done. Kindly, my lord, consider what injustice has been done to the petitioner.
Put the other side on notice once again and come back and show me some authority. I don't think I can do this.
I think, Lord, I'll come back with authority. If it's not a conscious abandonment of the petitioner, if there's any misconception on what ought to have been the line of action, then, my lord, your lordships have occasionally also permitted, my lord, that leave to be subsequently appended. Now that I've sought withdrawal, yes, I'll come.
Affidavit of service. None appears for the respondent. It can order have can 1 or can 2 of 2023. None appears for the respondents despite service. Paragraph, let the matter appear under the same heading on 4th September. Paragraph, the petitioner is directed to serve further notice upon the respondents intimating the urgent date.
Lord, I only pray for one indulgence. Would your lordship, Lord, be kindly please, Lord, to record that in the event there is no representation, the matter is likely to be taken up in their absence.
Not on the first date. Let us see. 4th September. Bad case for you, sir. 22.
There are authorities. I will satisfy your lordship.
My lord, I am happy on behalf of the applicant, my lord. Dismissed for default on 4th July, my lord. I served the copy of the restoration application to the, my lord, my main deed petition, my lord, consider my representation.
Affidavit of service, scan 1 of 2023. Affidavit of service. This is an application for restoration of the was dismissed by an order passed on July 4, 2023. Paragraph, sufficient grounds being made out, comma, the application is allowed. Paragraph, the writ petition, the order passed on July 4, 2023 is set aside. Paragraph, the writ petition is restored to its original filer number. Can such and such is disposed of.
I pray for leave to edit the respondent, Chief Engineer, Sundarban, Development Board, my lord. I added the respondent, man. Pray for leave to amend the cost title, man.
Only state,
My lord, he wrote a letter to the petitioner, Chief Engineer, Sundarban Development Board, not a party, my lord. I pray for leave to edit respondent, my lord. He wrote a letter,
matter, what is the matter?
my lord, unauthorized construction, page 37, my lord. My lord, I have the copy of all respondent, my lord. Every service, man.
Show the affidavit. Private
All respondent are service. Tag report delivered.
Panchayat, private respondent, there are several.
All are respondent, man. Page 37 in my representation.
কি ফাংশন আছে দাদা জমিটা কাজে
All respondent are delivered. Tag report, man.
Oh, Jila Purishad has also constructed Paka restored room. The construction running. It's good. No, I mean, construction of the
This 37.
Yes, what is the matter about?
My lord, unauthorized construction over the government land, page 37, representation, my lord. Page 37. The petition wrote a representation to the all concerned of an application for removal or demolition of illegal unauthorized construction over the government land. Under that number 3559, page 38, my lord.
কোথায় কি
Page 38 onward. my lord.
Public land as well as private land, you say?
No, my lord, it's a government land, my lord.
Please come to your representation, the subject.
Subject, my lord, an application for removal or demolition illegal unauthorized construction which have been illegally constructed by the government opposite party. Opposite on the private. Then it acquired as per the letter of the PW engineer. I'll submit the letter, my lord. The assistant engineer wrote a letter to the HOE engineer.
দেখি ফেব্রি পানি
A representation.
দাদা দেখেন এই রিপ্রেজেন্টেশন an application for removal.
Development, my lord, board is the authority, my lord. The PW engineer wrote a letter.
So there was an earlier writ petition.
My lord, he may not have made a party, my lord. Sundarban Development Authority, my lord.
Earlier writ petition filed by you.
Yes,
What
my
was
lord.
the order in that writ petition? What was the subject matter?
Earlier, the petition not made a party to the Sundarban Government Authority.
Have you made party there?
My prayer for leave to add the respondent number.
What was the subject matter of the earlier writ petition? Because it is taken action.
Unauthorized construction over the government land.
The same issue.
Same issue, my lord.
Steps have been taken.
But not made a party, my lord, earlier did petition, my lord.
Only to make a party you have filed. a
Yes, my
separate-
lord. Respondent number 25, I pray for leave to cost title, my lord. Page number, cost title 24, all the respondent, my lord. 25, Chief Engineer, Sundarban Development Board, my lord.
Filed an earlier writ petition on the same cause of action, right?
My lord,
Pursuant to the writ petition, steps have been taken by the authorities.
yes, my lord.
So
But-
why have you filed the present writ petition?
But Sundarban Development Board, not a party, earlier did
That
petition.
cannot be a ground for filing a fresh writ petition. Can that be a ground for filing a fresh?
When not today, my lord, earlier writ petition, I submit the earlier order and writ petition, my lord. I not today, my lord.
So I find there's a similar writ petition.
No, my lord, earlier writ petition is lying with my chamber, my lord. Not today, my lord.
Please give a copy of this to Mr. Dey.
Yes, ma'am.
Mr. Dey, please see this.
Present petition is state that the construction made by the Jila Parishad. Today I am not bringing this copy of the petition, only for students. I cannot decide.
Are they two separate encroachments? That's also do not follow.
Earlier writ petition not lying with me, my lord.
You will come with that earlier.
Then
Because it appears that they've taken steps.
Yes, ma'am.
Please come back.
if
Yes. But at a Xerox code, no.
WPA তে order করুন, let the matter appear under the heading one motion on 31st August. Please come back, come with all the documents.
My Xerox copy of the said report, my lord, and take back the.
Xerox copy টা।
প্যারাগ্রাফ কি বলেছে? হ্যাঁ, এই আর্লিয়ার petition copy দিয়ে দাও।
দিয়ে দেবো।
23.
Second thing. Other side is.
Oh, thank you.
Respondents,
I'm for the respondents, my lord.
But petitioner before lordship is a trust doing charity. The property has been let out to the respondent. This is a government authority, and relying on Dwarkada's Marfadia, I am praying for maintenance of the writ petition. But what happened, my lord, their revision we prayed for, and the committee constituted by them has revised twice, or rather thrice it has been revised.
the rent.
Rate, they revised. But now they are not acting on the basis of the revised. They have done.
Since 2007.
First revision kindly come to page 64 or 61. 61. It is kindly see the bottom. That is their committee constituted by them.
Yes.
This is one. This thereafter, my lord, kindly come to 64. Again, the committee has revised. It has been now said 25.50 per square feet. And my lord, 65, your lordship will find they have agreed to pay that rate. 65 and 66. Then my lord, kindly consider why order 12/6 will not apply.
You have assailed a notice. What is it? What is the
No,
notice?
we have
about?
assailed, not notice. We have assailed, my lord, the non-payment.
Cancel the impugned memo dated.
Yes, that is, my lord, your lordship will get at page.
December 9, 2021.
No, they, order 76. They want, after the assessment by the committee constituted by them, they want to reduce it from that. Again renegotiated. They want. Thrice, my lord, hearing committee decided it. They agreed to pay twice. Then, my lord, we are doing charity by virtue of this, my lord, rent income. We are doing charity.
This notice is on 7 June 2021.
29 December 2021.
You are challenging 9th December 2021 notice.
9 December. Right.
Prayer A,
Just a minute, my lord, let me find out for you, lordship.
Should be 29.
My lord, they have typographical mistake, 29th December, page 76. So জায়গাটাই ভুল বাবা। কি হলো?
did you attend the meeting?
Yes, yes, they decided that. May I repeat? What happened, my lord, there is a committee by them.
No, no, all that is all right.
They agreed to pay on the basis of the revised rate.
Then they wanted to reduce.
Then they want to reduce it.
And they called you for a
So
meeting.
meeting,
Have you attended that meeting?
we given a reply that why did further meeting? If the meeting by your hiring committee will decide that.
As communicated by the memo dated December 20. What is the I need a detailed representation thereafter?
But today, may I pray this thing? I have made a representation. Let them come with a report on the basis of the representation.
Where is your representation?
That, my lord, your lordship will get at page last annexure of your lordship brief, 79. And representation talks of about their hiring committee, the agreement to pay, and this, nothing else.
Yes.
My lord, before I come to that, my lord, this is made on the basis of a lease agreement, my lord. It is annexure page 56, annexure P3. In that lease agreement, my lord, at page 59, lordship can find that there is a provision for arbitration. Paragraph 17. Should any dispute or difference arise out of concerning the subject matter of this present or any convenient cause of things therein contained or otherwise arise out of this, there is an arbitration provision. My lord, that arbitration proceeding should be, my lord,
You're
followed
aware of the
first.
settled principles, sir. Will this
Well,
help you?
My lord, when there
Are
is
the
a,
petitioners debarred from approaching a writ court? Even if there is an arbitral clause?
as my lord, what is appears, my lord, it is a long disputed thing, my lord, that they want to revise the amount.
They do not
And
want. It is your suggestion. They only want implementation of your suggestion.
in that case, my lord, it appears that
Will you come
they are
back with
not
a
the
comprehensive
authority.
report?
They are not the authority to finalize the amount. They had to send it before the THQ, my lord, headquarter. And headquarter directed them to renegotiate. That's why they approached them for renegotiation. This is what, my lord, what my direction is.
Will you come back with a report
Yes.
upon consideration of the representation submitted by the petitioner? It's a comprehensive representation. Once you decide on an amount, what authority do you have to reduce the same or even propose for reducing the
My
same?
lord, this amount was
It
proposed
cannot be
and it was,
arbitrary, isn't it?
lordship,
It cannot be arbitrary.
lordship, it was proposed to them and that
And
was sent
accepted.
sent to the headquarters for finalization or approval. That was approval is not made, and they have sent it back for renegotiation at a lower amount. As it appears from their notice that they have already reduced their place and they have also already given away some property. They're not in the original leasehold property. So
They're saying about the abatement of rent for the reduction. There is no reduction of space. The entire they are using it.
So, my lord, that has been done. So if your lordship kindly direct my lord, it's a different thing, my lord. Otherwise, there is a arbitral proceeding, my lord, that can be.
I have just said,
My
I
lord.
repeat, an arbitration clause does not preclude the petitioners from approaching a writ court.
Lordship,
No longer rescinding.
lordship, lordship.
You're making the same submission
Then, my lord,
on merits.
on merits that I have already done. So
There
headquarter
cannot be a
has
proposed
refused that amount.
finalization, isn't it? The proposal for enhancement was made only after finalization.
No, 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 no. That was
How can there be a
proposed,
proposal first and then sent for
they,
finalization
they
later?
proposed for agreement, then it was forward to the headquarter. Headquarter made that it is not proposed amount. Is my lord page 76.
Please come to page 66.
69 also, 69.
Upon negotiation, you have agreed to this.
Yes. Kolkata division agreed that, and they had communicated before the headquarter. This is what informed to me.
This letter doesn't say it was communicated for finalization or something.
It was communicated there, my lord. Then, my lord, by a letter dated, my lord, 9th of December 2021. My lord, it was sent back to the Kolkata division for renegotiation, my lord.
It was
What I have
placed
done.
before the committee and the committee approved it. So what
Yes.
what further finalization was required? And was the petitioner informed that this is only a provisional decision?
No, that was not.
To be finalized by the
Only the headquarter refused that. That's why it could not be made. my lord.
cannot be done arbitrarily. There should be some ground. What
Then, my lord,
authority does the
file a
headquarters
report in
have?
that case, my lord, if your
Yes.
lordship directs. I shall file a report about that, my lord, if your lordship directs,
The
my lord.
court will now direct. If you come back with a report, I can grant you opportunity. Otherwise, I'll dispose it of here and now. Directing you to pay. There's no other option.
Then, my lord, I shall file a report, my lord. 4 weeks, my lord.
Mr. Basu, let him come back.
4 weeks.
When we are facing, we will be facing criminal, we have been threat with criminal proceedings, charitable
4 weeks.
2017.
Affidavit of service.
Respond number 4, respond number 4.
It is submitted on behalf of the.
My lord, one thing is, before my lord starts, my lord, one thing can be deducted, the admitted amount may be paid. What they are admitting may be paid.
That has
What
been
are they
paid.
admitted?
That has been paid.
Whatever they are admitting, so enhancement, 2007, there is no revision. Whatever amount they are agreed,
It appears that we are paying, my lord.
no, no,
We are paying.
2007 rate.
Yes, yes, we're paying. There is no dispute that we are not paying.
So,
We're paying.
Is it
But
a
not by
suggestion that will be
enhanced
no enhancement?
That is to be
They
decided.
are paying the 2007.
7.
Yes,
Come back
Is it
next
their
month.
guess there is no
Come back
enhancement?
next month. I'll deal with the matter.
lordship.
It is submitted on behalf of the petitioner that the land of the petitioner was leased out. It was a lease,
Lease.
leased out to the respondents by virtue of a deed of lease
Hey, बोल के respond number 4 report करो. Next, respond number 4.
executed on
Oh, probably 97. I was giving the exact date.
executed on 16th March
Check from 1st August 20.
1997.
Lordship.
I'm correct?
Lordship.
Yes,
16th March 1997. Stop.
and it is a
The
effect from 2002.
or with effect from that is not stated.
1st August 2002.
With effect from 1st August 2002. Stop. The petitioner complains that the last revision of rent was made in the year 2007. And though subsequently the respondents agreed to revise the rent payable for the said property, comma, they subsequently they issue subsequently they petitioner, comma. They have sought to renegotiate the rate of rent and in fact reduce the same by a letter issued to the petitioner on 29 December 2021. Paragraph. The respondents seek to submit a report in the form of affidavit in this regard. Paragraph, let the matter appear under the same heading on 30th August.
As my lord pleases. I will be praying for little earlier if possible.
Respondent number
This is
4,
charitable organization, my lord.
First 2 weeks I'll not be there to.
2 weeks, my lord will not be here.
respondent number 4 will give
Kindly direct the respondent 4 to consider and
Regional
file a
Director.
report. So he is the person.
Kolkata division.
Paragraph, report in the form of affidavit be submitted by the fourth respondent upon service of advance copy to the petitioner.
Lordship,
Fourth respondent on the urgent date upon service of advance copy to the petitioner.
Weather is good there.
Yes,
Weather is good there.
it's raining.
Rain is different type.
Lordship,
I'll not be writing poems.
Not necessary. Not necessary.
I don't need the rains.
But you have to enjoy the rain also.
This matter also, I am for the petition. This matter relates to the
Petition is not maintainable. Petition is not maintainable, madam. That is a specified act.
Specified.
My lord, if your lordship, before
What is your
मैं
prayer?
एक मिनट आके तुम्हारा आगे my lord, if your lordship come page 8.
I'm only paying
Act
for
with- act
for
with
the
the-
consideration of one representation, one after one.
Page 8,
It's
my lord.
connected to the specified act, it cannot be considered.
Now, my lord, have you seen, my lord? Page 8.
SS acquisition
Now, my
act.
lord, prayer.
You have referred to an estates accusation act. I don't know what act. it
Estate
is.
acquisition act.
It is an accusation. You have read stated accusation.
Yes. Now, my lord, page 98. That is the representation.
The prayer
Prayer, my lord, page
25,
for
25,
consideration.
23, past 24,
24.
Page 98 is the representation.
20, 98. Yes, my lord.
Representation at 98.
What is this, sir? Everywhere you have stated West Bengal Estate Accusation Act.
Wrongly typed.
Everywhere.
It is only type. আরে বোকা এটা ঠিক করে টাইপ করো।
I'm sorry. Cannot be considered. It's under the, you're asking for a record of rights, correction of record of rights, etc. Specified act. This is under the Land Reforms Act.
Only to be the representation may be considered.
Cannot
Lordship.
be done. Cannot be done.
Case is this, Lordship, that the
Representation under the Land Reforms Act also cannot be considered by this court. You have to approach the appropriate forum. Will you withdraw to dismiss on this ground?
but the difficulty was the order of the 1980 that is not complied with.
Can't help, sir.
It-
Can't help. Despite having full sympathy with you, I cannot help. The law doesn't permit.
And all the orders in my favor. That's all. That
The
is
law
also-
doesn't permit, sir, to see whether they are in your favor or not. You have to, I give you two options are there for you, sir. You can either withdraw and approach the appropriate forum or have to dismiss on this ground.
I'm withdrawing and
The matter pertains to the West Bengal Land Reforms Act 1955.
West Bengal Estate Acquisition Act.
Yes, it's
State
West Bengal Estate
a
Acquisition
West Bengal Estates Acquisition Act.
1953.
Paragraph. The petitioners seek to withdraw the writ petition and approach the appropriate forum for redressal of their grievance. Paragraph, in view of the above, the writ petition being WPA such is dismissed for non-prosecution. Paragraph, liberty is granted to the petitioners to approach the appropriate forum for redressal of their grievance. Paragraph, there shall however be no order as to costs as a certified website. Can't help. Next.
25.
25, my lord, I am for the petition. This is my affidavit of service, my lord.
Only the state
Only statement.
served.
Yes. Service has been effected.
Mr. De, may I request you? Please serve a copy to Mr. De.
Yes.
Copy of the writ petition.
Copy there.
Yes, what is the matter about?
Matter about, my lord, the Panchayat authority, my lord, taken the land of the petitioner, my lord, and undertook a Pakka road, my lord, without initiating any such process of acquisition and acquisition, my lord. I made a representation to the land acquisition, special land acquisition officer, BDO, and the Panchayat authority, but they are not taking any step.
They have utilized your land
Yes, my lord.
without acquisition.
Yes.
Where is your representation?
My lord, page 16.
Consider.
BDO will consider, not Panchayat. BDO
BDO will
consider.
BDO will
Panchayat
consider.
Yes, Panchayat is not, I am not for Panchayat. Panchayat has not any authority, my lord. BDO is the authority. BDO will consider.
Video has been made a party, yes.
Fourth respondent.
Fourth respondent, yes. Affidavit of service.
Yep.
None appears for the respondents despite service. Mr. Dey, who is present in court, regularized quorum, copy service and direction. Paragraph, the petitioner complains that his land has been taken away by the respondent authorities without acquiring the same by due process of law. Paragraph.
My lord, he is.
I've just
For the
appointed Mr. Dey.
I'm sorry, my lord.
No, no, my lord, no.
Shall I add your name to
Yes,
this?
ma'am.
কেটে দিন ওটা অ্যাপয়েন্টমেন্টটা কেটে দিন দেখুন
Your কাছে consider করতে।
My lord, kindly see the instruction, my lord. And kindly record this as well. Land acquisition officer has said that there was no land acquisition proceedings.
admitted. You've taken away his land without acquiring.
lord,
Not by the land acquisition or LA department. It was done by the Panchayat.
My lord, only for that is, my lord, BDO will consider that. The appropriate. BDO will consider, my lord. We have land acquisition.
ওটাকে
without a
রেকর্ডে নেই।
হ্যাঁ।
হুম।
ওই none appears to কেটে দিন বললাম the petitioner complains তাই না?
My lord appointed both of us, my lord, otherwise, my lord.
Yes, yes, yes. Mr. Dey or Mr. Dhar দুজনকে I'm not appointing, I'm just putting your names
Yes,
because he's already appointed. Paragraph. Placing reliance on the written instructions
কাগজ দিন।
submitted by the Special Land Acquisition Officer within bracket General, Howrah, Learned Counsel for the respondents submits that according to available office records, the land in question has not been acquired and no proposal for acquisition of the said land has been received by the authority. And as such, the authority is not responsible for paying any compensation to the petitioner in respect of the said land. Paragraph. It appears that the petitioner has submitted a representation before the concerned authority ventilating his grievance on concerned authority on 27th December 2022. Ventilating his grievance, which has not been considered till date. The petitioner, stop, the petitioner pays for a direction upon the authority to consider the representation at the earliest. Paragraph in view of the above, the petition is disposed of, directing the fourth respondent to consider and dispose of the representation submitted by the petitioner dated such and such within 2 months.
Yes.
Within 2 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof. Paragraph, in the event the representation is decided in favor of the petitioner, the authority is directed to take necessary consequential steps thereto within 1 month thereafter. Disposed of,
I'm declared.
Five.
26.
In 26, my lord, was
Fine.
directly responded to file.
yes,
My lord,
not ready.
my lord, I am for the private respondent, my lord.
Petitioner,
26 and 27, my lord, 4 times your lordship passed order, my lord, directing to file report.
yes,
Part of this point was.
you are appearing for the petitioner?
My lord.
My lord, the 26 choices.
This is 26.
26 choices.
Part of this point was not written on national or shackles, let me submit now that this
Take
matter.
the microphone, please.
This matter comes under the definition specified act. My land friend has asked.
In violation of the principle of natural justice, that's why your lordship asked for report. That
My lord,
no
may I-
notice was served behind the back, my lord.
My lord, may I
Well
submit, my
Yes.
I am for the respondent, madam. What their grievance is, the grievance of the petitioner is that he has not been properly served and the order was passed ex parte. Sir, only on the advocate's letter, your lordship, what he has sought for, the recalling of the order which was passed ex parte. There is a appeal provision, your lordship, under section 54. If he has agreed with the order, your lordship, he should have filed an appeal before the
He's pleading
proper forum.
violation of natural
My
justice. How do you deal with it?
Your lordship,
He's pleading violation of natural justice.
your lordship,
How do you
violation.
deal with it? If he has not been heard at all, no.
No,
notice
no,
has-
your lordship, he has been properly served in the order. It is all itself reflecting, your lordship. He was party in the OA application which was filed, and this order was passed in compliance to the order
That
of the
is order.
learned tribunal, your lordship, for speedy disposal.
And
He lose interest,
I
your
would
lordship.
directed the
I'm not-
authority.
I'm not on merits at all. Is there any document to suggest that the petitioner
Fine.
was served when the,
Served.
prior to the hearing? Is there any?
Tribunal
document?
directed to her.
I'll call 27. Please wait, madam, I'll call 27.
Your lordship, extremely sorry, your lordship.
Any document to show that the petitioner was served?
Yes, your lordship, it is in the order itself
It is-
reflecting,
it is
your
the
lordship.
tribunal.
Service.
Your lordship, continuation of the order, your
Tribunal
lordship.
tribunal directed the BLRO to heard the matter upon notice.
Notice was such, your lordship.
That is the
I-
tribunal matter, but the tribunal only dispose of directing them, BLRO to heard upon notice. Well, no notice was served, my lord. And the petitioner is a poor villager, my lord, lady, my lord.
Kindly come to the annexer P4, your lordship. Order of dated 15/7/2019.
Page.
Page, your lordship, at 18.
Yes.
BA is hereby directed to issue notice to all concerned filing date of hearing on. Your lordship, it was issued.
Where is the service, sir? Issuance is not service.
Your lordship.
Any document to show it was served? And this is only a direction for issuing. Where is the issuing? Issuance.
Issuance was
Where is it?
there.
This is a direction to issue. Please show me that it was actually issued and served.
Your lordship, kindly come to your lordship, page 20.
Yes.
Order dated 23 September 2020, your lordship.
Order, isn't it?
notice duly served, service return filed with the case record.
Where is the service?
Record is
Where is it? Where is the service return? I want to see that.
service record responded,
That's why respondent has to come with a report.
let it come with the report. Yes, ma'am.
If you can show that it was served upon the petitioners, the petitioners
only-
have no
only-
case before this court.
Yes, only my lord, at page 21,
Yes.
order number 12, it has been recorded that notice duly served, service return filed with the case record.
Yes, I want
But-
to see this service
Yes,
return.
but that service return has not been placed before my lord. So kindly allow me to file that.
Notice,
Only on one
service
issue,
return is-
that service of notice was done
Yes.
yes,
on the
sir.
petitioners.
And
Then
it is in the record. It is in the record. If they produce the record, it will
Absolutely.
be accepted.
That's what the state wants to come back with the report.
Your lordship.
Next matter is similar, my lord.
Learned counsel for the state respondents seeks extension of time to submit the report in the form of affidavit as sought. Huh? Paragraph, let the matter appear under the same heading on 5th September.
Yes.
The last chance, you're keeping it as a last chance, your lordship.
First chance, sir.
First chance.
This is the first extension that they've sought.
Yes.
Why last chance?
Earlier, direction was party, that's why I.
On the occasion it was passed, on the last date.
Yes.
Next.
September.
27.
27, I am for the state matter, I am filing my report, my lord. Present your lordship's direction.
Have you served?
My lord, I am appearing for the respondent number 5.
May I have a copy, my lord?
Served?
I'm grateful to you.
Pursuant to your lordship's direction, my lord, I am submitting, my lord.
My learned friend challenging the order passed by the prescribed authority under section 50 of the West Bengal Land Reforms Act. My lord, specific provision 54 before the appellate forum. My lord, and if your lordship kindly say the prayer, page 8.
Was the petitioner heard by the authority?
Yes, page 20. Page 20 of the writ application.
Similar, my lord.
Page 20.
Yes.
My
page
lord,
20.
on 10/11/2022, my lord, first 9/11/2022,
Issue notice.
then issue notice upon the interested parties, then 18/11/2022, notice duly served, service return filed with the case record, the petitioner, both the parties are present on call.
I would like to see the service return actually. Have you annexed it to your report?
But service it is not annexed, my lord, but my lord, can you see my lord page, my lord, 3 of my report, my lord. Page 3, paragraph Roman 3. My lord, now my lord, mutation application has to be done through my lord online, my lord. That is why the online, my computer
Herein, my
notice
lord,
were
is
issued.
necessary. As because the necessary party, Rayat is there, my lord, excluding the right of Rayat.
My lord, order has been passed. Both the parties are present.
Is it recorded in the order that both the parties are
The
present?
petitioner,
Yes, yes.
both the parties are present on call
Page 20, man,
on 18/11/2022.
Page
20, man.
20, page 20. 18 November 2022. The petitioner, both the parties are present on call.
It is before the tribunal.
Order has been
Thereafter-
passed by the competent authority
And thereafter tribunal directed
under section
tri-
50 of the West Bengal Land Reforms Act. An
Direct-
appeal provision is there 54
tribunal directed to dispose of.
and everything.
Dispose of,
Everything-
to বলে নিতে দিন।
You are challenging this order?
My lord, not, my lord.
Yes.
I am not challenging this order.
They are there.
আমাকে
Page
বলতে
8.
দিন একটু please. My lord, tribunal directed dispose of this application, directed the BLRO to heard the matter, mutation application upon notice to all the respective parties.
Yes.
That notice I am asking, my lord, no notice was served, my lord, and behind the back of it was, my lord, granted. That I am saying.
If any violation of the order of the landed tribunal, my lord, he has as forum before the tribunal, as well as, my lord, if any notice has been served.
আমি
under
চ্যালেঞ্জ
section
করিনি, I am
50,
not challenging.
that has to be
Yes,
also, my
please
lord,
stop.
51.
1 minute, 1 minute. You have actually asked for setting aside the order dated 9/11/2022,
9,
not the subsequent orders. Please come to your prayer A.
nine, 11.
Ninth 11 is the entire order, my lord.
9/11
which,
is
my
not
lord,
the entire order.
My lord,
The
ninth,
subsequent orders
is
are
the-
of 10,
my lord,
11,
this is-
18, 11.
this is, my lord, with reference to top, my lord, case of reference is there, my lord. A case reference there. In this case reference of 9/11/22, my lord. And this tribunal, my lord, petitioner by through his learned advocate, entered appearance. But
The order demonstrates that you were present before the authority at the time of hearing.
before the tribunal, my lord, before the tribunal,
Tribunal, come to page 20, you were present.
before the tribunal petitioner present, my lord.
Page 20 is not the tribunal, sir. It is under section 50.
My lord, nowhere, my lord, they can produce, my lord. It is, my lord,
The
on
order
behalf of
says you were
somebody,
present.
somebody is entered and they have, my lord, this is the manipulation going on. They are poor people, my
And
lord.
so this is a specified act, this
My
could
lord,
not.
only thing, my lord, both are equal matter, my lord. They have to produce, my lord, the service, my lord, affected on the petitioner, my lord. I will, my lord, go out.
The order records that you were present and you have placed your
My lord, that
submission.
is to produce, my lord. Where is the service?
I repeat, the order impugned records your presence.
My lord, with
So
great
that
respect, my
indicates
lord,
that it was served.
service itself not made, my lord.
If your
Service of
presence
someone
is-
itself.
If your
Someone-
presence is recorded, service is not necessary. It automatically, we can. infer that
Somebody,
service was
somebody on
made.
behalf of learned advocate, on behalf of my lord, appeared, my lord, and entered his appearance. This is the manipulation going on, my lord, on behalf of the petitioner.
Please approach the appellate forum, I have to dismiss it on this ground.
My lord, make it adjournment for a day, my lord. I am praying, my lord. My lord, my
No
colleague is
question.
there, my lord, only for a day. Only for a day.
Page 37.
I am praying only for a
My
day.
landed friend client
How do you
also
prove
filed
your
Hajira.
case?
Only for a day, my lord, I will.
Why? Why do you want an adjournment?
My lord, I will make appropriate submission, my lord, in this regard. Only for a day, your lordship kindly adjourn.
Let both the matters appear together.
My
lord.
For a moment, page 37, my landed friend's client also filed Hajira. That was specifically my lord, page 37. For a moment, my lord, kindly look it. My landed friend, my lord, challenged the order passed on 9/11, page 37. My lord, that was passed on 21/11/2022. Notice duly served, service returned, filed with the case record. The petitioner, both the parties are present on call. The petitioner, both the parties filed Hajira, which are made part of the proceedings. And on 21st November 2022, order has been passed in presence of my learned friend clients. And my learned friend challenged the order passed on my line 9th
Mr.
November
Bhagwan, have you
2022.
annexed the service return?
That has been served through my computerized service, my lord. I do not know what is the meaning, my lord.
Computerized service, where is that?
Okay, page, my lord, page, my lord, 3, my lord.
Page?
Page 3, para Roman 3, my lord. Computerized notice were issued as per the present computerized module. So, Roman 3, para.
My lord, everything happened in presence of my learned friend clients. He
Yeah.
also filed Hajira before the
My lord,
This is a different notice of the hearing.
notice of the hearing.
Where is the notice of hearing?
My lord,
My lord, my learned
They
friend
have
also
applied-
filed Hajira.
Please allow the others to speak, madam. Please have some patience.
my lord, nowadays, my lord, the mutation application, my lord, has been submitted through online, my lord.
I'm
And
not talking about mutation application at all.
And the
A
notice,
hearing took place.
yes, my lord.
Notice was directed to be served upon the petitioners
Yes.
prior to hearing. Where is
Yes.
that notice?
That notice is not annexed in the report, my lord.
Please come back with another report.
Why?
Take this back, come back with a report annexing the notice. That is the only issue here.
Yes, yes.
If notice is served, the petitioners are out of court. Otherwise,
Yes.
it has to be taken up.
Yes.
It has to be reconsidered otherwise, isn't it?
Yes, sir.
Please come back with a notice showing notice of service.
My lord, every
Rather
day
service
my
of
learned
notice of
friend
petition.
clients were not appeared by filing Hajira. My lord, from 9th November
ওনাকে বলতে দিন।
2022 up to 21st November 2022, matter was heard in
So
different days.
the authority should be having the documents.
Yes.
The
That was-
Hajiras,
in the order sheet, that was reflected, that file Hajira.
Hajiras should be, will you come back with a report?
Yes, sir, I shall file my press
Is
report,
that
my
you?
lord. Yes, sir.
It's a report now.
Learned
Report
counsel
now.
for the
He is asking for
state
report.
respondents seeks further extension of time to submit a report in the form of affidavit demonstrating service of notice of hearing upon the petitioners. Paragraph, let the matter appear under the same heading on, the earlier date was 4th
Fifth September.
September. Same date.
Same date, 5th September.
In report of notice. Nothing else is required, only
Yes,
service
yes,
of
only
notice.
service. So the give them just submit.
Next. 29. 29.
Lordship, I am for the petitioner here.
Yes.
The petitioner was declared as the highest bidder and LOI was issued. And subsequently, when the petitioners went for verification of the spot, sand block, it was found that there was no mineable sand in the block. Even the sand block was situated within nearest the school and mosque and middle of the portion. Therefore, the petitioner made an application for shifting of this sand block. That application,
Alternative block.
Lordship, shifting or alternative?
At the very outset, I would raise the point of maintainability. In 2017, he participated in the tender. In 2020, it was pointed out that there is no mineable reserve after 5 years.
No.
Kindly
By the-
Lordship, consider the conduct of the petitioner.
Lordship,
In 2007, he participated in the tender without going through the area in which he is submitting bid for mining purpose. He submitted the bid. And after 5 years, even after extension of time for LOI and time for environment clearance,
no.
then he came to his knowledge that there are no mineable reserves. My learned friend will rectify me if I am factually incorrect.
So that is there, but the fact is that from the very inception, the petitioner was several times made a representation verbally, but writtenly they are made a representation on Lordship on 16 September 2022.
Have you stated that in your writ petition?
Lordship,
Paragraph?
Lordship, paragraph 9. The petitioner said during the site verification, it was found there was no mineable sand in the sand block. Moreover, it may be emphasized on the fact that firstly, as per the coordinates mentioned in the letter, the sand blocks could not be identified. Secondly, as per the rectified coordinate issued by the district authority, the subject sand block situated in the middle of the village and behind the school, namely Sultanganj such and such. And bridge located within 270 meters from the plot, and for which the plot of sand blocks does not qualify as viable mining site. In as much environment issuance in such circumstances, the petitioner did not proceed with the further for environment clearness and execution of mining lease.
These all are happened subsequent to March 2022, and he submitted the bid in 2017.
Lordship, whatever it
The
is,
statement
application.
regarding verbal representation, nothing is on record.
That is what I
Representation
asked.
for the first time in September 2022.
Lordship, the verbal representation that why Lordship.
Have you
no
stated
statement
in your writ petition?
I'm-
That you have made several verbal representations? How do you explain the delay?
verbal Lordship. Lordship, prayer kindly paragraph 12 that I've stated. The petitioner has substantial all the facts and supports the praying thereby to shifting the sand block to the but the respondent authorities have not considered the prayer of the petitioners.
So that this indicates that they were written representations. This is not verbal. This cannot be verbal.
Lordship, written
are they-
representation is made, but the verbal representation, Lordship, perhaps it has not been stated
No,
by.
that is there.
That is
Cyberman is
also
not
one
there.
after 10. Paragraph 10. 10 is the representation on 16 September 2020. Then my lord comes 12. Then my lord, he substantiated 10. Only one representation.
Representation is the fact is there. Don't let it, the representation may be considered.
Without going into merits, I can direct consideration of representation, and you are aware as to the fate of the representation. Now it's.
Lordship, that may be, but the
The question is that the fact is that
If you are
the
still
sand
having
block
the
is,
consideration, I'll give a direction for consideration.
Lordship, I am only praying for that.
The mineral development, the state is vehemently opposing your representation.
Let them submission be recorded. That I can do this. What is my instruction?
Record our submission and then remand it to the ADM for consideration. Right? Chandika?
Facts and admitted
Some more
position is
time
there.
will be spent on this. Representation at page.
Page 24. Page 24.
ADM একটু করে
ADM.
এগুলো ডিএম করে না
না, না, ADM. ADM.
রিপ্রেজেন্টেশনই হয় না
Petitioner sat silent after depositing the entire bid money.
Lordship,
Entire bid amount was deposited.
deposited.
Then the petitioner remained silent.
Depends on but it was found.
It's 1/3.
1/3.
No, they say entire bid amount has been deposited.
Entire bid amount was very small.
Before LOI, entire bid amount.
That bid amount was very small. That's why the petitioner has paid the entire bid amount.
Paragraph 5.
But the procedure is after the
One
LOI,
third.
1/3, and at the time of
The
execution.
bid man money was small. That's why they paid the entire bid money at a time.
They say they have deposited the entire amount. So I'll just record the submission.
No. Which got any?
Heard learned.
Hey, affidavit
counsels
service be
for
kept
the
to the record.
purpose. Show the affidavit service.
No. Which got any?
এই অ্যাপিলেট অথরিটি ভালো এসছে বলে করছে নাকি
হ্যাঁ, বিহার ভারতী।
তারপরে তো এগুলো রিজেক্ট
It's
করা
contented
কনসিডার দেওয়া হবে না
being the highest bidders in the e-auction floated by the authority. Letter of intent was granted in favor of the petitioners who paid the entire bid amount in terms of the letter of intent on 20th March 2017. Stop.
এর আগে টাকা দিয়ে নেওয়ার আগে তো সবকিছু দেখে নেবে জায়গাটা এখানে তার ব্যবসা
যেখানে ইসি বা কোনো এর জন্য ডিলে হয় ইলিগালি তুলে 5 বছর হয়েছে বাড়ি টাকা ফেরত দেবো অন্য জায়গায়।
In the process of obtaining environment clearance for commencement of mining, comma,
তুলে নিয়ে খোলা বাজারে বেঁচে দিয়েছে।
petitioners learned, the petitioners found
লোকাল পঞ্চায়েত
that the
থানা ধরে পয়সা দিয়ে মাল তুলে
block
নিয়ে বেঁচে
in
দিয়েছে।
question
এটা হতে পারে স্যান্ড ব্লক এগুলো কি
was not viable for
মেজারমেন্ট ছাড়া
sand
কোনো action
mining
হয়?
since there was no mineable sand in the block and the block was situated in the middle of a village behind a school and a mosque and railway bridge were located within 270 meters of the block. Stop. The petitioner submitted a representation before the concerned authority seeking shifting of the block to an alternative site suitable for sand mining, comma, or submitted a representation যেখানে বললাম না, on the date on 16th September 2022 before the concerned authority on 16th September 2022, তারপর seeking, which is yet to be considered. Stop. The petitioners pray for a direction upon the authority to consider the representation at the earliest. Paragraph, it is submitted on behalf of the respondents that though letter of intent was issued in favor of the petitioners, in 2017, comma, the petitioners remained silent for a period of more than 4 years for more than 5 years and chose to submit the representation only on 16th September 2022. Stop. The delay remains unexplained. Paragraph, be that as it may, comma, since representation submitted by the petitioner before the authority is pending, comma, the writ petition is disposed of, directing the
Fourth respondent.
concerned authority being the fourth respondent herein to consider and dispose of the representation within 1 month,
Lordship.
within 1 month from the date of communication of this order, upon affording reasonable opportunity of hearing to all the stakeholders, including the petitioners, comma, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioners within a week thereof. Paragraph, it is made clear that this court has not gone into the merits of the case, and the authority shall be at liberty to deal with the representation submitted by the petitioners independently in accordance with law.
Great.
Disposed of which apply.
Great. On the second one,
Next.
this is also the identical matters.
Mr. Shah,
Date, representation date is same. Representation is same, but here LOI is also same.
LOI is also
Same.
LOI টা issue হয়েছে আগেরটাতে 20th March 2017 বলেছি।
LOI is also same. 10th January 17.
Representation same date?
Same date, not same date.
So same order?
Yes.
Same order.
Affidavit service সেটা একটু বলে দিচ্ছি। Lordship, this is the third one.
Give me a minute, please.
Lordship.
Yeah, এখানটা চেঞ্জ করুন। The facts are different. ওই জায়গাটা চেঞ্জ করুন। ওটা কি বলেছিলাম আগেরটাতে বলুন তো?
Sir, yeah, Lordship, the
No mineable reserve, তাই তো? তাই বলেছিলাম তো? Mineable reserve code, mineable reserve in the mineable reserve code, mineable reserve, Santa in the block and এই যে এখান থেকে বাদ দিন এখানে করুন and the block, হ্যাঁ, and the block consists of fertile soil
Lordship.
suitable for cultivation, for which the local people have raised objection to any mining activity therein. এটাতে ঢোকে।
Grateful, Lordship.
Yes, next. The facts are different.
Here, Lordship, something is different.
31.
Lordship, 3. This is also same. 31. I'm for the petitioners. This is also same, but here, Lordship, the after LOI lease deed was executed. 8-3. No, 7-7-9. 7-7-9. Lease executed, and Lordship, the sand block was under the deep water, where boats were using for transportation.
An order.
Lordship.
It's confused.
Here also, lease was executed 2019.
And the application,
90.
the
He ought
representation,
ought to have come to the knowledge of the petitioner prior to lease was granted because he has obtained environment clearance prior to execution of the lease. And in 2022, after 3 years of the lease executed, it came to his knowledge that there are no mineable.
No, no, no,
It's
এখানে-
under river, the ferry-ghat is there.
Objection করছে আজকে। Objection করছে। Affidavit service requested.
affidavit of service. Paragraph. Learned counsel for the petitioner submits that being the highest bidder in the e-auction floated by the authority for grant of long-term mining lease.
They are just indicated because nobody is appealing for this state.
So they,
In this matter, no one for the state.
Yes.
yes, I have served the notice, but Mr. They is there.
Should have mentioned this.
I was under the impression that I.
Yes, obviously I was also.
May I request you? ওটা non, এ করুন, আগে affidavit of service non appears for the state respondents. Mr. their appointment regularize করুন, copy service এ direction. Please have a copy.
Lordship, I'll serve.
ঠিক আছে? Regularize করুন, copy service এ direction. কি বললাম? Bring the. And upon depositing the entire bid amount, comma, a deed of lease was executed in favor of the
Page 20, Lordship.
petitioner. Executed and registered for a period of 5 years on 10th May 2019.
Lordship.
Stop.
As stated in paragraph 8, Lordship.
In the process of obtaining environment clearance for the said sand block, comma, the petitioner found the petitioners found that the sand block did not have adequate mining reserve and was therefore not suitable for excavation. Stop. The petitioners submitted a representation in this regard before the concerned authority on 16th September.
Lordship, 16th
16th
September.
September 2022, which is yet to be considered. Stop. The petitioners pray for a direction upon the authority to consider the representation at the earliest. Paragraph, it is submitted on behalf of the respondents that though deed of lease was executed in favor of the petitioners in 2019, comma, the petitioners chose to submit the representation before the concerned authority only in 2022, comma, that is, after lapse of 3 years. More than 3 years, after lapse of more than 3 years, stop. The delay has not been explained. Paragraph, be that as it may, paragraph, comma, this court is inclined to hold that since the representation submitted by the petitioners is pending before the concerned authority, comma, the concerned authority being the
Four, Lordship.
fourth respondent hearing, comma, be directed to consider and dispose of the representation within 1 month from the date of communication of this order, upon affording reasonable opportunity of hearing to all the stakeholders, including the petitioners, comma, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioners within a week thereof. Paragraph, it is made clear that this court has not gone into the merits of the case, and the petitioners shall, and the authority shall be at liberty to deal with the representation submitted by the petitioners independently in accordance with law.
Great.
Disposed of which?
Great.
Next is also yours.
Lordship, next one is also same. Here is also the lease deed was executed
Next.
and date was also same.
Item 28 fixed at 12:30.
No, no.
Same matter as far.
Matter last date আছে
32.
30 স্যার একটুখানি
Same order.
এই এভিডেন্স স্যার
Yes.
Lordship, the year is Lordship, the date of LOI is the same and the registered lease was registered on 10th May. That is the same 2019. The date was same. The present date is also same.
Same order. Affidavit of service. A fact they can. Please 10th May 2019. Since not suitable for mining, change. Since there was no mining reserve in the block, reserve in the block, and the entire block was submerged in deep water. Remaining same.
Lordship,
State.
grateful, diplomat.
Special fix.
28.
My learned senior friend Miller to clarify Miller his position. Miller remembers me of the matter 8
Properties,
yes,
the 8
yes, yes.
undemarcated, yes.
And undisclosed also, not only undemarcated, undisclosed, Milord, unidentifiable
Which
properties.
have been-
Exactly. So, and Milord, there is a report filed which says that Milord, inquiry is under contemplation. That's Milord, what is Milord, the report
Process under
says.
contemplation.
Yes, Milord, may I just show Milord that particular paragraph. Now, Milord, law provides for Milord a particular Milord procedure to be followed under the act, under the rules.
So these appearing in this one, the state.
Report.
Let us hear the learned is.
Yes, Milord. If Milord just kindly Milord have a look at page 18 once of Milord the report.
18.
18. The last paragraph at the foot of page 18. Just to show that Miller's admitted position of fact, Miller, that nothing has been identified, earmarked, nothing has taken place. Internal inquiry, Miller.
Is about to begin.
And before that, Miller, that newspaper publication has come up.
Yes.
But I understand the Lordship have been pleased to direct us to come up with an instruction. And the last order.
Specifically to the effect that which are the 8 plots which have been invested.
Yes. Now, my lord,
The entire property.
yes. Now, my lord, I have
Have you served a copy of this?
criminal instruction. If my lord direct, I can serve.
They need to have a look.
This was not mere an instruction on affidavit.
Yes. So please serve copy.
Yes.
I'm grateful. Thank you.
Now, my lord, your loss.
Are you ready today? You want to go through?
Yes,
this?
we are ready.
Ready?
Now, Lordship will kindly appreciate this fact that what is the locus standi of the petitioners? There are 16 petitioners. They are all promoters. developers. They have come before the court for setting aside a notification vesting the property to the custodian, and the other prayer is for demarcation. Now, not a single document has been annexed in support of their claim, either the owner's deed or their lease deed. Nothing. They have come before the court on the basis of a searching report of a lawyer. Therefore, whether in such a case, the order for demarcation can be passed, number one. Secondly, my lord, your lordship is aware that whosoever is aggrieved by a notification or date of knowledge of the property being vested to the custodian shall, within 30 days from date of knowledge or the notification, shall make an application if he is aggrieved to the Government of India for deciding such issue. In other case, in item number 33, which was yet to be called out, your lordship has been pleased to direct that application has to be made to the Joint Secretary of Government of India representation for invoking the jurisdiction under Section 18. Now, if somebody is dissatisfied with the decision of the Joint Secretary, the law provides there is a provision for an appeal. Now, my lord, if your lordship today directs demarcation, what are the documents that shall be relied upon by our authority? Number one. Number two, the power which is vested to the custodian. It does not include demarcation. It is a limited power given to the custodian. I am just reading out the power of the custodian. This is Section 8. Kindly look at Section 8. Power of custodian in respect of enemy property vested in him. With respect to the property vested in the custodian under this Act, the custodian may take or otherwise the taking of such measures as he considers necessary or expedient for preserving such property till it is disposed of in accordance with the provisions of this Act. 2. Subsection 2. Without prejudice to the generality of the foregoing provision, the custodian or such person as may specifically authorized by him in his behalf may, for the said purpose, carry on the business of the enemy, fix and collect the rent, etc., take action for recovering the money due to the enemy, make any contract and execute any document in the name and behalf of the enemy. Now, Roman 4 is institute, defend or continue any suit, and then the last one is secure vacant possession of the enemy property by evicting the unauthorized, and then raise on the security of the property and incur out the property, any expenditure including the payment of any taxes and transfer by way of sale, mortgage, etc. And nowhere there is a power vested to the custodian to demarcate a property in case of such a dispute. Now, my lord, the owners cannot be shifted to the Government of India by the petitioner. Whosoever comes to read court, he has to satisfy the Honorable Court that he has a case. Why is the document annexed in support of their candidature? Only a lease deed of the enemy properties, enemy that has been annexed here, and subsequently, if your lordship kindly looks once in the list to the searching report of a lawyer who is one GHOSH, that is the sole claim. Now, if your lordship today directs for demarcation, what are the documents on which we shall rely on?
Your own documents, sir. Please come to the public notice
Public notice.
issued by your authority. At page, this annexure P8, 195. This has been primarily assailed in the writ petition.
No, just a minute. Yes,
At page 196 also.
yes, that 96, yes, also.
Yes.
This can be done by notification, by a general order, whether they are not questioning whether the property does not vest to the custodian. Whosoever comes before the court, that we have a right, he has to satisfy what are the rights they have. The whole simple purpose of the petitioners is to sell out the flats and construction made unauthorizedly in respect of the enemy property.
The public notice says that out of the entire property, 8 properties are vested.
Yes.
So which are the 8 properties which are vested? The simple
I
question.
respectfully agree with your lordship.
I just want to know which
But
are the
what
8 properties.
locus standi they have to have an order of demarcation, unless they satisfy they have a right, that not a single document is annexed to the writ petition, except the searching report of a lawyer. They must have a case of either indefeasible title, or even if it is a lessee, which they have claimed here, the lessee must have derived a title from a person that those documents are to be annexed.
They claim to be joint lessees.
What are the documents?
The lease deeds are annexed, I believe. Yes.
Kindly have a look at paragraph 8. Milord, my short reply on facts.
Paragraph 8.
8 minutes of the writ petition at page 12. Which is not in dispute, even Milord, in the report, in the affidavit submitted by Milord, the custodian. Milord, I have craved leave to rely upon all Milord, the title instruments are Milord with me here and now. Milord, I can show. And Milord, I just Milord did not annex it, only Milord to Milord cause less trouble to your lordship, Milord to hand.
Let that be annexed. You shall have a
If
position to
the
reply to that.
is challenging your title, your local standard, you need to come back with your documents.
There is one. My learned senior friend is also suggesting that Milord, he does not have Milord any obligation to demarcate. Milord, this submission Milord falls flat because of Milord the rules Milord prescribed under the act. Kindly Milord just have a look at the rules once, Milord, which is Milord immediately after Milord the act.
Yes.
Kindly take Milord rule 4. Milord, this is enemy property rules 2015.
Yes.
Milord, framed under the Enemy Property Act in exercise of powers Milord conferred under the Enemy Property Act. If my lord will kindly get it Milord in the preamble of the rules. Kindly Milord take rule 4. Procedure prescribed Milord for declaration and vesting of enemy property. Milord, this exercise has not been undertaken. That is Milord admitted in the report Milord filed Milord by of an affidavit. And Milord, my learned senior friend is representing Union of India. The central government, the custodian cannot say that there is no procedure prescribed. It shows his ignorance, the custodian's ignorance of the statutory rules. Even the responsibility is cast upon him. He does not even know that. How to discharge his duties as a custodian, he doesn't even know that. And the submission before a constitutional court is that there is no procedure prescribed.
Yes.
Rule 4 does not say the power is vested to the custodian for demarcation. First of all, Milord, I am surprised to hear a submission from the petitioner. It is well settled law, either in the civil court or the writ court. A petitioner who comes before the court for high prerogative jurisdiction relief, he has to establish his case. Let the documents be produced. It may be a fake transaction, or there may be no document at all.
Please come back with a supplementary affidavit annexing your deeds.
Tomorrow, Milord, I'll do it.
Yes.
Tomorrow, I'll do it. Milord, I will serve.
Saturday.
Oh, Monday.
No.
Monday, my lord is not here.
Not be here for 2 weeks. So you will come
And my
back.
lord, also kindly take note of rule 3. Kindly, my lord, also take note of rule 3. Kindly just, my lord, have a quick look at rule 3. Provides for, my lord, identification with, my lord, demarcation. না যশা বুঝতে পারছিস তো? And my lord, surprisingly, and my lord, interestingly also, rule 3 and rule 4 say my lord, if the custodian wants to declare, my lord, any property as enemy property, my lord, he has to give notice to the persons who are going to be affected. My learned senior friend is suggesting that, my lord, we are strangers and he doesn't even know, my lord, his client doesn't even know, my lord, who have, my lord, any semblance of interest in the property. Without knowing that, my lord, he cannot even declare the property, my lord, as an enemy property. He must first ascertain, my lord, that's his duty to ascertain, my lord, who has any semblance of interest in the immovable property. It's his duty, my lord, to find out and then, my lord, to put them on notice and then, my lord, proceed to, my lord, declare the property as enemy property.
Has the report disclosed?
No, it doesn't.
Rule 3, I am reading out. Procedure for identification of immovable property. The custodian may seek assistance of the district authority for examination of the tehsil-wise or block-wise revenue records for the purpose of identifying any immovable property belonging to or held in name of an enemy or enemy subject to enemy farm. Where is the question of demarcation unless they establish their title? All right.
Kindly turn to, my lord.
But why is refusing to file a
I am
document?
not refusing, my lord. Kindly have a look at sub-rule 1 capital A.
That shall be decided after filing his supplementary affidavit.
The authority has to deal with, has to check the revenue records for identification.
My lord,
Identification.
I respectfully agree. But who can challenge this or say this? Whosoever has prima facie discharged his burden that he has a right for such identification. Where is the document in the writ petition?
Please come back with your document.
I will.
He must discharge his burden.
But
They are
my lord,
aware of all these things from 2019. This is purely, my lord.
my lord, kindly keep these submissions, my lord, in mind because my lord will not be there.
Hopefully. I've been hearing it for quite some time.
That's
so-
true. That's true. If my lord so feels, if my lord kindly records also, my lord, these submissions that my lord,
I'm not lucky.
very.
Instruction in the form of affidavit submitted on behalf of instructions in the form of affidavit submitted on behalf of respondent numbers 1 to 5 are taken on record. Paragraph heard learned counsels for the parties. Paragraph learned counsel for the respondent numbers 1 to 5
See, whatever you feel.
challenges the locus standi of the petitioners to raise the issue in question in the writ petition. Learned counsel submits that the petitioners have no nexus whatsoever with the property in question and can therefore not challenge the process of what is it called? Vesting. The process of vesting undertaken by the authority. Paragraph learned counsel for the petitioners seeks to use a supplementary affidavit annexing relevant documents. Paragraph, let the matter appear under the.
My lord, kindly also give us leave to reply to the supplementary affidavit. It may be, my lord, we have to take instruction.
My lord, we will do it, my lord, by Tuesday. My lord, kindly issue a peremptory direction if my lord so feels.
Where is
So-
the urgency? I do not know. Every time this is being urged. Yes, my lord. Where is the urgency?
My
If they
lord-
succeed in the writ petition,
My lord has
they shall get
already
everything.
appreciated the urgency.
They are in a hurry to dispose of the flats unauthorizedly constructed.
Are
If they are entitled, they can, isn't it?
Yes, definitely. But what is the urgency?
They can come
Urgency,
to the court that it is unauthorized.
no, urgency we have been taught is that a matter where tomorrow, we cannot wait till tomorrow or day after tomorrow. It is pending before your lordship. Kindly give us 7 days time to give the reply.
On prayer, on prayer of the respondents, liberty is granted to use an exception to the supplementary affidavit, exception for reply code.
May it be peremptorily within 7 days.
Get 14 days.
Kindly,
remaining.
my lord,
So,
this much of
paragraph,
indulgence.
let the matter appear under, please be ready with your exchanges in the meantime. Let the matter appear under the same heading on 25th August.
Very. My lord, we are being flooded with complaints from, my lord, the prospective owners. And that's the difficult.
25th August.
Grateful.
Time marking. Next. 33.
33, I also, my lord, appear for the respondent.
33.
I am for the.
Well, Mrs. Indranee Chakraborty, repair report, Union of India, question number 3. But she has not come to the court because of her illness. I'm praying not to do. Honor.
I am appearing, but
Sir,
actually, lordship knows, my lord, since I am a senior advocate, I cannot appear without a junior. That is the, under the Advocates Act. So if she is ill, she hasn't come to court, then kindly place it on Monday.
The senior has not been informed.
No, nothing, nothing.
But the similar case, my lord, the Enemy Property Act, a lord,
It's not similar case, it's a different matter.
this is the lord's earlier order, passed an order on page 128.
Today, the council is not able to continue, so come back some other day.
Or lordship, only one thing, my lord, my learned friend, senior friend already appeared. Lord, I think, my lord, this will be required for affidavit, because, my lord, I have challenged the order.
You've challenged the order.
Challenge the order. Senior friend is here, my lord, I know, my lord, the.
So will you come back on affidavits?
Very well, ma'am.
Yes,
Very well.
think it is required.
Yes, it is
So order
required.
is
It is
challenged.
required because there are certain facts. Apart from the fact that your lordship had been pleased on the earlier occasion to grant, and had been pleased to grant them leave to make an application under section 18. And that has been made and that has been rejected. Now, these grounds of rejection and other things are to be adjudicated on affidavit.
So please come back on affidavits. Upon hearing learned counsels for the parties, comma, this court is of the view that the matter needs to be heard on affidavits. Paragraph, affidavit in opposition be filed within 2 weeks.
My lord, it is Home Secretary, New Delhi. So kindly give us 4 weeks.
Within 4 weeks from date. Stop affidavit and reply, comma, if any, comma, be filed within a week thereafter. Within a week thereafter, paragraph, let the matter go out of place for the time being. Liberty to mention.
Yes.
Lord, the lordship is fixing the date, my lord, so that, my lord.
Liberty to mention. After completion, mention. Next, 34.
Lordship, I am for the petitioner. I am led by learned advocate Mr. Sabyasachi Mukherjee. Lordship, my senior is very ill. I am praying for only 1 week of accommodation.
Have you served? Do you have the affidavit of service?
Lordship, I was not instructed. Lordship.
On prayer of the petitioner, the matter is adjourned. Let the matter appear under the same heading on 5th September.
I am for the petitioner, my lord. My lord, in this matter, 35, my lord, in this matter, Mr. Santanu Kumar Mutru appear for the, on behalf of the state, my lord. He is engaged, my lord, code number 550, my lord. Kindly not today, my lord.
Let it be adjourned.
Let it be so Monday, my lord.
Not Monday, I'll give you a date. You are filing the affidavit of service.
Hey, my lord, I completed. Allow me to submit.
Affidavit of service. On prayer of the state respondents, the matter is adjourned. Paragraph, let the matter appear under the same heading on
Oh, no.
1st September. Oh,
Yes,
ready?
my lord. Yes.
Yes, so we can
Actually,
have you served the panchayat?
there are,
Have you served the panchayat?
no, my lord. Panchayat is not actually necessary parties here.
The due and payable amount is 4 lakhs, 2,91,540.
If you want to expunge the name of the panchayat.
Expunge, let it be here.
Let it expunge.
Huh.
Very good. Yes, what
The
is the matter?
merit of the case is that the several coercive and illegal measures was adopted by the respondent, particularly the respondent number 2, in respect of payment of loyalty, my lord. I am coming one after another, man. First of all, the respondent number 2 demanding money to the extent of 4 lakh 94 thousands from me on account of royalty for the year 2017 and 2018, when the brickfield was not in operations. And that is reported by the SDLO to the DLRO. But DLRO not yet considered that representation. That letter.
An exemption has been given, my lord, and total, my lord.
প্লিজ আমার বলতে দিন, আমার চারটে স্যার আমাকে বলতে দিন। নাম্বার 2, the SDLRO compelled me to pay a sum of the amount. Accordingly, I paid 1,50,000 of the out of the 4,95,000 rupees, my lord. And after that, they have refused to accept the entire royalty since 2018 till date. And as a result, huge money was accumulated there. Number 4, the respondent number 2 and 3, they have made a contradictory assessment of the royalty. I'm coming one after another. Kindly have a look on page 34.
Yes, 34.
Is the notice given by me to the BLRO that my brickfield was not in operations. That is the notice. After this, considering this, the SDLRO, kindly look at page number 41.
Before that, your lordship, kindly see page 38.
Please, একটু আমার মামলা করতে দিন না আমাকে দাদা। Page 41.
Yes.
Annexure P8. Report regarding closure of Asa bricks. This is my brickfield. That this report was sent by the SDLRO to the DLRO, but that was not considered. After that, they have forced me to pay a sum of rupees. I'm coming. Page 35, man. No. Page 35. Sorry. It is 32, man. No.
Yes.
I'm coming. Just a minute. Allow me to place that record, my lord. Page 37. Page 37.
Yes.
They compelled me to pay 1,40,000 out of 4,94,660. After that, they did not allow me to deposit any royalty for the year 2018 to 2022. After that, they have sent a entire chart. Kindly have a look page 38.
Yes.
This is sent by the respondent number 3, the SDLRO. It is here 21,41,000, and here 2017-18 already shown, but its amount is they have calculated it is 3,45,000. But in their earlier slip, they have claimed 4,94,000. That anomaly. After that, the respondent number 2, they have sent an assessment. Kindly have a look next page, 39. Page 39. They have asked me to pay 19 lakh. Here it is 21 lakh, or here it is 19 lakh, 91, 94, 98.
This is for
This
21,
amount.
22.
There is a anomaly between the two charts. I have made a representation, my lord, elaborate representation before the authorities, particularly the respondent number 2. Kindly have a look on page 48. Respondent number 2 and respondent number 3. They let the exemption be allowed for the year when the brick field was closed down. That is for the year 2017 and 18, and another all the rest payment be made in installment. 4 installment I sought. That is my contention. And a fresh assessment be made.
Lord, kindly takes his representation, which is at page, my lord, 48. Your lordship kindly takes, my lord, the chart at page 49. Has your lordship got it? Chart. This is the chart. And my lord, your lordship kindly takes page 50, paragraph 9 and 10, point 9 and 10. What he says? May I please, my lord? In the meantime, the applicant received a notice dated 3rd March 2023 from the office of the DRNLRO, Paschim Midnapur, to pay a total sum of rupees 19,91,948 up to 2021 to 2022 without allowing exemption for the closure period. That is 2017-18, which is contrary to the royalty chart set by the respondent number 3. The applicant submits that since the closure, that is 2017-18, has been inquired and verified by the BLRO, the applicant is entitled to the exemption for the amount to the tune of rupees 4,41,548 forthwith, and a fresh assessment is required to be made to enable the applicant to pay of the fresh assessed outstanding royalty for the year 2018-19, 19-20, 2021, 21-22 in 4 installments of 6 months each, since the outstanding amount became extremely heavier owing to non-receipt of year-wise royalty on the year-wise assessment. In view of the above facts and circumstances, the applicant has no other option but to request your honor to allow exemption of such and such duties that I don't know to assess, being aware of the brick-field was not in operation, and allow the applicant to deposit fresh as his outstanding amount. Your lordship kindly takes the report. For your lordship assistance, this report has been prepared, and your lordship would find.
You served a copy to the.
No, my lord, it's a report. No, your lordship has not directed me to file a report. For your lordship assistance, my lord, I have prepared a report. আরে কিছুই না, একই জিনিস আছে। My lord, your lordship kindly takes my report. My lord, first page, my lord, last paragraph. Eventually, the BLRO Devna uncovered the fact in the form of a report followed by physical observation upon the land in question in terms of the operational status of the said brickfield. Video is office memo number such and such to the office of the SDLRO Kharagpur. The report itself does not exhibit the closing status of the brickfields. Following this, a prayer for exemption was submitted by the petitioner dated 27 March 2020. That is the representation I have already placed before your lordship. To this office of DLLR, Paschim Midnapur, over the issue of demand amount in rupees 2,91,548. Lastly, the petitioner admits in the representation he has been ready to pay all outstanding royalty. So, meters 2,91,548 is due and payable. It is government revenue, government money. Milord, he may be directed to pay, Milord. After the exemption has been given, Milord, or upon Milord field verification, your lordship has seen.
To consider the representation upon hearing the petitioner.
Upon hearing the representation, Milord, this Milord amount has been arrived at. So it's a important government revenue, Milord.
Have you heard the petitioner in disposing of the representation?
No, Milord, we have not.
Representation has not been disposed of, not been
Lordship.
considered.
Yes.
It is only after the petition that you have come up with this report.
No, in terms of the representation, this amount has been arrived at. Without hearing him, Milord, he has Milord furnished a representation that has been Milord.
Needs to be heard.
He has not been heard.
hear the petitioner and dispose of the representation. Yes?
Well, two things here. My representations given to the PLRO and SDLRO be considered, and my claim of considered for exemption of the amount.
That is stated in the representation
Yes,
itself.
ma'am.
He has already, said that he would pay, outstanding dues.
No.
Except the.
No.
27.
What shall I pay?
Paragraph 9
No,
and 10, your lordship can-
no. I'm not. Why shall I pay? When my Brickfield was closure, it is closed down.
Enable the applicant to pay of the fresh assessed outstanding royalty.
Assessment.
Yes, that
Yeah.
after exemption has been given,
Ask for fresh assessment.
that has
Yes,
been
yes.
done, and in terms of the assessment, some exemption has been
It
given.
has been done in absence behind the back of the petitioner.
Then in terms of his representation,
Yes, so he has to be heard. It is his representation. Can it be assessed in behind the back of the
on the
petitioner?
basis of the representation, on the basis of the field inquiry, this decision has been taken.
Field inquiry should be in presence of the petitioner.
That has been done.
Representation has to be dealt with in presence of the petitioner. Has that been done?
Well, this is the inquiry report, your lordship kindly sees. No, he has not annexed the inquiry report.
No, that was a day.
Yes, forwarding report letter is there. Inquiry report must be with the forwarding report. Page
is not-
41.
Why
Yes.
don't you consider the representation and hear out the petitioner? Whatever
Lordship,
he has to say.
kindly direct.
Approach the authority, let
Yes,
the
ma'am.
authority hear you.
Yes.
And
On the basis of document.
and submit on relevant documents to the authority.
Yes. On the basis of annex with the writ petition.
Your lordship kindly takes page 41. 41, your lordship kindly sees. What suppression he has made. This is the report after field verification and with the enclosure, your lordship sees. Report of
This
the.
is sent by whom to whom? Not the petitioner. This was sent by the SDLRO to the additional
Yes.
district magistrate.
DLR, yes, ma'am.
Not to the petitioner.
Yes.
So how can the petitioner?
I have collected it from his office.
He has already got it.
He has collected this, not the report. Let him consider the representation. Evidence of service. Instruction submitted on behalf of the respondents is taken on record. Paragraph, it is contended on behalf of the petitioner that the petitioner is running a brick kiln, AILL, in the name and style of Asha Bricks Industries, inverted comma mode, Asha Bricks Industries. The plots in question. Upon payment of trade like upon payment of land revenue and his trade license is renewed from time to time. The petitioner was unable to operate the brick kiln for the year 2017-2018. You were
Yes, madam. 1718.
2017-2018.
That period was closed down.
Due to labor crisis and dearth of brick earth. And notified the same to the Block Land and Land Reforms Officer as well as to the Subdivisional Land and Land Reforms Officer. The the brick kiln was operation of the brick kiln. The operation of the brick kiln was resumed for the subsequent periods from 2018-2019, 2019-2020, 2020-2021, and 2021-2022. Stop. The petitioner was not allowed to deposit the royalty for the subsequent periods without depositing royalty for the period 2017-2018 when the brick kiln was not in operation. The petitioner deposited an amount of rupees 1,50,000 in reply to a demand notice.
Yes, ma'am.
In reply to a demand notice issued by the authority, comma, on advice of the authority. Stop. The assessment of royalty made by the DLLRO also differs from that of the BLNLRO.
Yes,
They are
ma'am.
different.
DLRO report first, then SDLRO.
They are different. The
Yes.
assessment is different.
Yes.
The petitioner received a notice from the office of the DL and LRO on 3rd March 2023 directing payment of a total sum of rupees 19,91,948 up to 2021-2022 without allowing exemption for the period 2017-2018, which is contradictory to the royalty chart prepared by the
SDLRO, madam.
SDL and SDLR. SDL and LRO হবে subdivision land and land records office সবগুলোতে SDL and LRO BLLR. The petitioner submitted a representation before the concerned authority on 11th April 2023 requesting exemption of rupees 4,41,548 assessed for the period 2017-2018 and allowing him to deposit the fresh assessed outstanding royalty for the subsequent periods. Stop. The said representation is yet to be considered. Stop. The petitioner pays for a direction upon the authority to consider the representation at the earliest. Paragraph. It is submitted on behalf of the respondents that some exemption has been granted to the petitioner upon consideration of his representation. Learned counsel candidly admits that no opportunity of hearing was
Your
granted.
lordship would not record it, my lord. Your lordship would not record it. Let it be court's order.
Correct. ওটাকে লিখুন। There is nothing on record to suggest that an opportunity of hearing was accorded to the petitioner prior to considering his representation. Paragraph in view of the above, comma, this court is inclined to hold that since the representation submitted by the petitioner is yet to be considered by the authority upon hearing the petitioner, comma, the concerned authority, comma, being the third respondent.
Respondent number two, my lord.
The second respondent.
Yes.
Be directed to consider and dispose of the same within 1 month,
6 weeks, my lord.
within 6 weeks from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner, comma, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof.
Lord, your lordship kindly records, my lord, your lordship has not gone into the merits of the case.
Paragraph, it is made clear that this court has not gone into the merits of the case, and the authority shall be at liberty to deal with the representation submitted by the petitioner without being influenced by any observation which may have been made in this order.
Extremely grateful, my lord.
I'm grateful.
Next matter, the lordship can dispose it of. So, the state court has filed a report, is going to file a report. I have
Come back, Mr. Court, it's time.
2 o'clock, Lord, would you?
I have a division bench at 2 o'clock today.
Oh, I see. Then, Lord, I believe you from next week, your lordship is not here.
Weeks.
But they have said that, Lord, the acquisition has lapsed. So after the
Come back.
division,
I don't think it will be possible. Please come back.